I never thought a storage unit would cost me everything. But when I found the padlock on my door replaced and my entire collection of professional tools missing, I knew my life was about to become a legal nightmare. My name is Samuel Harrington, and I have been a professional carpenter for 23 years. I moved to Riverside County, California, 3 years ago after landing a contract with a major construction firm in the area. The housing market was tough, so I settled for a townhouse in Meadowbrook Village, a planned community with strict HOA rules that I honestly did not pay much attention to when signing the papers. Big mistake. The townhouse came with a small detached storage unit about 50 feet from my back door. Nothing fancy, just a 10 by 10 concrete block structure with a roll-up metal door. I kept all my professional equipment in there because my garage was already packed with my personal vehicles and workshop space. We are talking about thousands of dollars worth of tools accumulated over 2 decades. Table saws, nail guns, power drills, hand planes that belonged to my grandfather, specialty measuring equipment, you name it. That storage unit was essentially my livelihood locked behind a standard padlock. Things started going south in March of last year. I came home from a job site around 7 in the evening, covered in sawdust and ready for a shower. As I walked past my storage unit, I noticed something was off. My silver master lock was gone, replaced with a shiny brass padlock I had never seen before. My stomach dropped. I immediately tried calling the HOA office, but it was after hours. Their voicemail said they would return calls within 48 hours, which seemed ridiculous for what I considered an emergency. I did not sleep that night. Every noise outside had me jumping up to look out the window, worried someone was ransacking my tools. The next morning, I was at the HOA office before they even opened. The management company, Prestige Community Services, operated out of a small office complex about 2 miles from my neighborhood. I sat in my truck waiting until I saw a middle-aged woman with an aggressively blonde bob haircut unlock the front door. I gave her 5 minutes to get settled before walking in. The woman behind the reception desk looked up with that practiced smile receptionists perfect over years of dealing with annoyed people. Her nameplate read Patricia Sullivan. "Good morning. How can I help you today?" she asked. "Someone changed the lock on my storage unit," I said, trying to keep my voice level. "I need to know what happened and I need access to my property immediately." Patricia's smile did not waver. "Let me pull up your account, name and address." I gave her the information and watched her type slowly with 2 fingers. The wait was agonizing. "Ah, here we are. Mr. Harrington, 2847 Willow Creek Lane. It says here that your storage unit was secured by our HOA board president, Brenda Morrison, due to violations of community storage regulations." "What violations?" I asked. "I have been keeping my tools in there for 3 years without any issues." Patricia clicked through a few more screens. "According to the notes, Mrs. Morrison conducted an inspection last week and found that your storage unit contained commercial equipment, which violates Section 8.4 of the Community Guidelines. Commercial business operations are not permitted on residential property." I felt heat rising in my face. "Those are not for a business operation. I am a carpenter. Those are my work tools. I go to job sites. I am not running a business out of my house." "I understand your frustration, Mr. Harrington, but the guidelines are quite clear. The board has deemed your tools to constitute commercial equipment." "Where are my tools right now?" I demanded. Patricia shifted uncomfortably. "The storage unit has been secured pending a board hearing to determine the appropriate course of action." "A hearing? When is this hearing?" "The board meets on the first Tuesday of each month. The next meeting is in 3 weeks. 3 weeks, I nearly shouted. I need those tools for work. This is my income we are talking about. I can submit a request for an emergency hearing, but I cannot guarantee it will be granted, Patricia offered. I took a deep breath. Please do that, and I want to speak with Brenda Morrison directly. Mrs. Morrison is not in the office today, but I will pass along your message. I left the office furious and immediately called my employer to explain why I could not complete the job I was scheduled for that day. My boss, thankfully, was understanding, but told me I needed to sort it out quickly because we had deadlines to meet. Over the next few days, I tried calling Brenda Morrison at least a dozen times. She never answered, and she never returned my calls. I submitted a formal written request for an emergency hearing through the HOA portal. No response. I consulted with a buddy who had dealt with HOA disputes before, and he recommended I document everything. I started taking photos of my locked storage unit daily, keeping records of every call and email, and writing down exactly what tools were inside to the best of my memory. Finally, after a week and a half of silence, I received a letter in the mail from the HOA. It was not about an emergency hearing. Instead, it informed me that due to continued violations of community guidelines, my storage unit contents had been removed and disposed of, and that I would be assessed a $500 fine for the violation, plus $300 for the removal and disposal costs. I read that letter 3 times, convinced I was misunderstanding something. They disposed of my tools, just like that. Without even giving me a chance to remove them or attend a hearing, I immediately drove back to my storage unit. The brass padlock was gone, replaced with my original lock. I fumbled with my keys and yanked open the door empty. Completely empty. The concrete floor was swept clean. Not a single screwdriver remained. 23 years of accumulated professional equipment gone. I stood there in disbelief, my hands shaking. Some of those tools had belonged to my grandfather, irreplaceable items with sentimental value far beyond their monetary worth. I called the HOA office from right there, and this time I did not bother keeping my voice down. Patricia answered with her usual cheerful greeting. "This is Samuel Harrington. I just got a letter saying you disposed of my tools. What the hell does that mean? Mr. Harrington, please calm down. As the letter explained, your commercial equipment was removed per the board's decision. Where is it? Where are my tools?" "They have been disposed of, sir. The letter explained that. You had no right. Those tools are worth tens of thousands of dollars. The community guidelines give the board the authority to remove items in violation of the rules. You were notified." "When? When was I notified?" "I got a letter after you already threw everything away. According to our records, a violation notice was posted on your storage unit door on March 9th. I wanted to scream. There was no notice on my door. Even if there was, you do not just throw away someone's property without due process." "Mr. Harrington, I understand you are upset, but I need to ask you to lower your voice or I will have to end this call. Transfer me to Brenda Morrison. Now, Mrs. Morrison is unavailable. Then have her call me, today." Patricia said she would pass along the message, but I knew that was not going to happen. I sat in my truck outside my empty storage unit and tried to think clearly. This had to be illegal. They could not just take someone's property and throw it away, HOA or no HOA. I needed a lawyer. Finding an attorney who specialized in HOA disputes in Riverside County was not difficult. California has strict HOA laws, and plenty of lawyers make a living fighting these battles. I scheduled a consultation with a firm called Davidson and Associates for the next morning. The attorney I met with, A sharp woman in her 40s named Jennifer Davidson listened to my story while taking notes. When I finished, she leaned back in her chair and shook her head. "They really screwed up," she said. "Even with HOA authority, they cannot just seize and dispose of personal property without proper notice and due process. California Civil Code Section 5975 is very clear about this." "So I can sue them?" I asked. "Absolutely. And frankly, you should. This is egregious." What they did was not just a violation of HOA procedure, but potentially criminal conversion of property. That word, criminal, made my heart race. What does that mean? Conversion is the legal term for taking someone else's property and treating it as your own or destroying it. Given the value you are describing, this could be grand theft. "I want to file a police report," I said. Jennifer nodded. "That's a good idea. It creates an official record and adds pressure, but the civil suit is where you will actually recover damages. I recommend we pursue both angles." I left her office feeling validated but also overwhelmed. I had never sued anyone before. The whole process felt intimidating. That afternoon, I went to the Riverside County Sheriff's Department and filed a report. The deputy who took my statement, a young guy who looked fresh out of the academy, seemed sympathetic but not particularly optimistic. "HOA disputes are tricky," he explained. "They are going to claim they had the authority to do what they did. It becomes a civil matter in most cases." "But they stole my property," I insisted. "Tens of thousands of dollars worth of tools." "I understand, sir. I am filing the report. A detective will review it and determine if criminal charges are warranted. But I am being honest with you, these usually get resolved in civil court." I left the sheriff's office frustrated but determined. Jennifer Davidson had agreed to take my case on contingency, meaning she would get paid when we won. That was a relief because I certainly could not afford to pay a lawyer by the hour while also replacing all my missing tools. Over the next few weeks, Jennifer got to work. She filed a lawsuit against the Meadowbrook Village HOA and Brenda Morrison personally, alleging conversion, violation of California Civil Code, negligent infliction of emotional distress, and several other legal claims I did not fully understand. The lawsuit demanded the replacement cost of all my tools, plus emotional damages, attorney fees, and punitive damages. Jennifer estimated my tools were worth at least $50,000 based on the inventory list I had painstakingly recreated. Some items, like my grandfather's hand planes, were irreplaceable. I also had to deal with the immediate fallout. Without my tools, I could not work. My employer was patient for about 2 weeks before he had to let me go. I could not blame him. A carpenter without tools is useless. I filed for unemployment and started draining my savings to cover my mortgage and bills. The HOA, meanwhile, sent me another letter demanding payment of the $800 fine and disposal fee. Jennifer advised me not to pay it, which just added to my stress. About a month after filing the lawsuit, Jennifer called me with an update. "Their attorney reached out," she said. "They want to settle." "Already?" I was surprised. "They know they are in trouble. Their offer is $15,000. I did a quick calculation. That was less than a third of what my tools were actually worth. That's insulting." "I agree. I told them we would not accept anything less than full replacement cost plus damages, but I wanted to keep you informed. They are going to try to lowball you." "What happens if they do not settle?" "We go to trial. And honestly, Samuel, I think that is our best option here. A jury is going to be sympathetic to your case. What they did was outrageous." The thought of going to trial terrified me, but I trusted Jennifer. "Okay, let's do it." The lawsuit moved slowly through the court system. Discovery was a nightmare. The HOA's attorney, a smug guy named Richard Kellerman, fought us on everything. He demanded proof that I actually owned the tools I claimed were taken, which was difficult since they were gone and I did not have receipts for items purchased years or even decades ago. But Jennifer was relentless. She subpoenaed the HOA's records and found some damning evidence. There was no record of any violation notice being posted on my storage unit door on March 9th, as Patricia had claimed. In fact, the minutes from the board meeting where they supposedly voted to remove my tools showed that only Brenda Morrison and one other board member, a woman named Diane Fletcher, were present. 3 other board members were absent, meaning they did not have a proper quorum to make binding decisions. Even better, we found an email exchange between Brenda and the property management company, where Brenda asked about disposing of my tools. The manager, Patricia Sullivan, had replied warning her that removing personal property without proper notice could expose the HOA to liability. Brenda had responded, "He's been a problem resident. Sometimes you have to make an example." That email was gold. It showed malicious intent. We also tracked down what actually happened to my tools. Brenda had not disposed of them in the sense of throwing them away. She had hired a junk removal company to clear out the storage unit, and that company had taken everything to a second-hand tool shop in San Bernardino. The shop had purchased the entire lot for $3,000, a fraction of the actual value. Jennifer subpoenaed the shop's records and got photographs of some of my tools. Seeing pictures of my grandfather's hand planes sitting on a shelf with price tags on them made me physically ill. I tried to buy them back, but the shop owner refused. He said he had purchased them legally and was not going to give them up. Jennifer explained that we could potentially recover those specific items through the lawsuit, but it would complicate things. The emotional toll of the whole situation was devastating. I had always been a pretty even-keeled guy, but I found myself unable to sleep, constantly anxious, snapping at friends and family. I started seeing a therapist, which Jennifer said would actually help our case since we were claiming emotional damages. My therapist, Dr. Lisa Patel, was helpful. She explained that what I was experiencing was not just anger but grief. Those tools represented my career, my relationship with my grandfather, and my sense of security. Having them taken without warning or recourse had shaken my fundamental trust in institutions and authority. "It's a violation," Dr. Patel said during one session. "Not just of your property rights, but of your sense of safety and control. That's why you're having such a strong emotional response." I attended therapy weekly, and Dr. Patel provided documentation of my treatment for the lawsuit. Jennifer said this evidence would be crucial in proving emotional damages. Meanwhile, the HOA continued to make things worse. They sent me monthly violation notices for unpaid fines. They threatened to place a lien on my property if I did not pay. Jennifer fired back with letters explaining that I was under no obligation to pay fines related to an unlawful seizure of property, but it did not stop them from trying. I also started hearing from neighbors. Word had gotten around about my lawsuit, and reactions were mixed. Some people were supportive, sharing their own horror stories about Brenda Morrison and the HOA board. Others seemed to think I was being unreasonable, that I should have just followed the rules. One neighbor, a retired schoolteacher named Margaret Chen, stopped me while I was getting my mail one day. "I heard about what happened with your tools," she said. "I just want you to know that not everyone agrees with what Brenda did. She's been on a power trip for years." "Thank you," I said. "I appreciate that. My husband and I got fined $500 because our mailbox was the wrong shade of beige," Margaret continued. "Can you believe that? We had to repaint it 3 times before they approved it. This HOA is out of control. Stories like that made me feel less alone, but also more determined. If we won this lawsuit, maybe it would send a message that HOA boards could not just do whatever they wanted. 6 months after filing the lawsuit, we finally had a trial date, November 14th. It felt like forever away, but Jennifer assured me that was actually pretty fast for a civil case. As the trial date approached, the HOA made one more settlement offer, $35,000. It was more than the first offer, but still less than half of what my tools were worth, and it did not include any emotional damages or punitive measures. I rejected it. "We're going to trial," I told Jennifer. "I want a jury to hear what they did." The week before trial, Jennifer and I spent hours preparing. She drilled me on potential questions the defense attorney might ask, warned me about tricks he might use to make me look bad, and coached me on staying calm and credible on the witness stand. "Richard Kellerman is going to try to paint you as someone who violated HOA rules and is now playing the victim," Jennifer explained. "He'll probably suggest that you were running an illegal business, that you were warned multiple times, and that you're exaggerating the value of your tools. Don't take the bait. Answer the questions simply and honestly." I tried to sleep the night before trial, but managed maybe 3 hours. I kept rehearsing my testimony in my head, worried I would freeze up or say the wrong thing. The trial was held at the Riverside County Superior Court. The courtroom was smaller than I expected, with rows of wooden benches and a judge's bench at the front. Our case was assigned to Judge Robert Martinez, a middle-aged man with a reputation for being fair but no nonsense. Jennifer and I sat at the plaintiff's table on the left. Across the aisle, Richard Kellerman sat with Brenda Morrison and a representative from Prestige Community Services. Brenda was exactly what I expected. Late 50s, perfectly styled blonde hair, expensive pantsuit, and an expression that suggested she was deeply inconvenienced by having to be there. Judge Martinez called the court to order and had us swear in. Then Jennifer stood to give her opening statement. "Your Honor, members of the jury, this is a case about a flagrant abuse of power. Samuel Harrington is a hard-working carpenter who stored his professional tools in a storage unit on his property. Without proper notice, without due process, and without any legal authority, the defendant Brenda Morrison and the Meadowbrook Village HOA seized Mr. Harrington's tools and sold them for a fraction of their value. This was not an enforcement of reasonable HOA rules. This was theft, plain and simple. We will prove that the defendants violated California law, destroyed tens of thousands of dollars worth of property, and caused significant emotional harm to Mr. Harrington. We ask that you hold them accountable and award full damages." She sat down, and Kellerman stood for the defense's opening statement. "Your Honor, ladies and gentlemen of the jury, this case is about a homeowner who repeatedly violated his community's rules and now wants to be paid for it. Mr. Harrington was operating a commercial business in a residential community, which is explicitly prohibited. He was notified of the violation. He was given opportunities to comply. He chose not to. The HOA board, led by Mrs. Morrison, did exactly what they are empowered to do: enforce the community guidelines that all residents, including Mr. Harrington, agreed to follow. There was no theft. There was no abuse of power. There was simply rule enforcement. We ask that you find in favor of the HOA." The first witness Jennifer called was me. I walked to the stand, swore to tell the truth, and sat down. My hands were shaking. Jennifer started with easy questions: my name, my profession, how long I had lived in Meadowbrook Village. Then she moved to the tools. "Mr. Harrington, Can you describe what you kept in your storage unit? I took a breath. Professional carpentry tools. I had table saws, miter saws, drills, sanders, hand tools, measuring equipment. Some of the items were very old, like hand planes that belonged to my grandfather. Approximately how much were these tools worth? Based on current replacement costs, between $50,000 and $60,000. Some items are irreplaceable because they're not made anymore. Jennifer walked me through the timeline, coming home to find a new lock, trying to contact the HOA, receiving the letter about disposal, discovering the empty unit. She showed me copies of the letters and emails, which I identified for the record. How did you feel when you opened that storage unit and found it empty? Jennifer asked. Devastated, I said, my voice cracking slightly. Those tools were my livelihood. Some of them were family heirlooms. I felt violated and helpless. What impact did this have on your employment? I lost my job. I couldn't work without tools. I've been unemployed for 8 months now. Jennifer showed the jury copies of my unemployment claims and bank statements showing my depleted savings. Then she asked about the emotional impact. I've had trouble sleeping. I developed anxiety. I started seeing a therapist because I couldn't function normally. Every time I drive past a hardware store or see someone working with tools, it's like a punch in the gut. Kellerman objected a couple of times during my testimony, claiming I was being speculative or overly emotional, but Judge Martinez mostly overruled him. Then it was Kellerman's turn to cross-examine me. Mr. Harrington, you described your tools as professional equipment, correct? Yes. And you use these tools as part of your employment? Yes. So you were operating a commercial business from your residence? No, I'm an employee. I work for a construction company. I just store my tools at home and drive to job sites. But you bring those commercial tools to and from your residence regularly? Yes, when I need to. And you never thought to check the HOA guidelines about commercial equipment? I paused. I did read the guidelines when I moved in. I didn't see anything that suggested I couldn't store work tools in my own storage unit. Kellerman pulled out a copy of the community guidelines and read section 8.4 aloud. It said commercial businesses and commercial equipment storage were prohibited without express written approval. Does that refresh your memory, Mr. Harrington? I never interpreted my tools as commercial equipment storage. These are personal tools for my job, but they are commercial-grade tools used for commercial purposes. Correct, Jennifer objected. Argumentative. Sustained, Judge Martinez said. Kellerman changed tactics. Mr. Harrington, how do you know your tools were worth $50,000 to $60,000? I've been a carpenter for 23 years. I know what tools cost. I went through and cataloged everything I could remember and looked up current prices. But you don't have receipts for most of these items. No, some of them I bought 10 or 15 years ago. Some were gifts or inherited. So you could be exaggerating the value. I'm not exaggerating. If anything, I'm underestimating because there are items I've probably forgotten. Kellerman tried to poke holes in my testimony for another 20 minutes, but I stuck to my story. When he finally sat down, I felt exhausted but relieved. Jennifer called several more witnesses. First was Margaret Chen, my neighbor, who testified about the HOA's pattern of unreasonable fines and aggressive enforcement tactics. Then she called an expert witness, a tool appraiser named Donald Rice, who reviewed my inventory list and testified that my valuation was conservative and reasonable. Based on the list Mr. Harrington provided, and assuming average to good condition, I would estimate the replacement cost of these tools at between $55,000 and $70,000, Rice said. Some of the vintage items, particularly the hand planes, could be worth significantly more to collectors. Jennifer also called Dr. Patel, my therapist, who testified about the emotional distress I had experienced. Mr. Harrington exhibited symptoms consistent with acute stress and anxiety, Dr. Patel explained. The sudden loss of his tools and livelihood, combined with the feeling of violation and powerlessness, created significant psychological harm. Then it was the defense's turn to present their case. Kellerman called Brenda Morrison to the stand. Brenda had clearly been coached. She spoke calmly and confidently, describing herself as a concerned community leader trying to maintain property values. "Can you explain why you decided to remove Mr. Harrington's tools?" Kellerman asked. Several neighbors had complained about commercial vehicles coming and going from his unit, Brenda said. "I conducted an inspection and found clear violations of our commercial equipment policy. I followed proper procedure to address the violation." "Did you provide notice to Mr. Harrington?" "Yes. A violation notice was posted on his storage unit door on March 9th. He had 10 days to remedy the situation. When he failed to comply, the board voted to remove the items." Jennifer's cross-examination was withering. "Mrs. Morrison, you say you posted a notice on March 9th. You have any proof of that?" "I posted it. I don't take photographs of every notice I post." "Were there any witnesses to you posting this notice?" "I was alone." "So we just have your word?" "Yes." "And you claim the board voted to remove Mr. Harrington's tools. How many board members were present for that vote?" Brenda hesitated. "2 of us." "Out of how many total board members?" 5. "So you didn't have a quorum, did you?" "It was an urgent matter. Mrs. Morrison, the HOA's own bylaws require a quorum of at least 3 board members to make binding decisions, correct?" "Usually, yes." "So this vote was not actually valid, was it?" Kellerman objected, but Judge Martinez overruled him and instructed Brenda to answer. "I suppose technically no," Brenda admitted. Jennifer then pulled up the email where Brenda had said she wanted to make an example of me. "What did you mean by that, Mrs. Morrison?" Brenda's composure cracked. "I just meant that we needed to enforce the rules consistently." "Or did you mean you wanted to punish Mr. Harrington for being, in your words, a problem resident?" "I never said that." "Really?" Jennifer showed the email to the jury. "These are your words, are they not?" Brenda stammered through an explanation that only made her look worse. By the time Jennifer was done, Brenda looked shaken and defensive. The trial lasted 3 days total. Both sides gave closing arguments on the 3rd afternoon. Jennifer's closing was passionate and clear. She walked the jury through each element of our case: the lack of proper notice, the invalid board vote, the malicious intent shown in Brenda's emails, the substantial value of the tools, and the emotional harm I had suffered. "The defendants want you to believe this was about rule enforcement," Jennifer said. "But the evidence shows something very different. This was about power and control. Brenda Morrison wanted to make an example of Samuel Harrington, and she didn't care what it cost him. She violated his rights, destroyed his property, and turned his life upside down. Now it's time for her to pay for what she did. We ask that you award full replacement cost of the tools, emotional damages, and punitive damages to send a message that this kind of behavior will not be tolerated." Kellerman's closing tried to reframe the case as a homeowner refusing to follow rules, but it felt weak after Jennifer had systematically demolished their defense. The jury deliberated for about 6 hours. I spent that time pacing outside the courtroom, unable to eat or focus on anything. Finally, the bailiff called us back in. The jury had reached a verdict. I stood next to Jennifer as the foreperson, a woman in her 60s, read the verdict. "On the count of conversion of property, we find in favor of the plaintiff, Samuel Harrington." On the count of negligent infliction of emotional distress, we find in favor of the plaintiff. On the count of violation of California Civil Code Section 5975, we find in favor of the plaintiff. My heart was pounding. Then came the damages. We award the plaintiff $62,000 for replacement cost of tools. We award the plaintiff $25,000 for emotional damages. We award the plaintiff $15,000 in punitive damages against defendant Brenda Morrison, personally. Total damages, $102,000. I nearly collapsed. Jennifer grabbed my arm to steady me. We had won. Not only had we won, but the jury had awarded more than we had even asked for in replacement costs. Judge Martinez thanked the jury and dismissed them. Then he turned to us. The court finds the evidence compelling that the defendants acted in bad faith and violated Mr. Harrington's rights. The jury's verdict is sound. Additionally, pursuant to California Civil Code, I am awarding reasonable attorney fees to the plaintiff, to be calculated and submitted within 30 days. That meant Jennifer would get paid, and I would not owe her anything out of my damages. It was a complete victory. As we left the courtroom, I saw Brenda Morrison talking urgently with Kellerman. She looked furious. I felt a grim satisfaction. Over the next few weeks, the reality of the verdict sank in. The HOA's insurance company covered most of the judgment, but Brenda Morrison was personally liable for the $15,000 in punitive damages. I heard through neighborhood gossip that she had to sell her vacation home to pay it. There was also a shakeup in the HOA board. Several residents, emboldened by my lawsuit, demanded Brenda's resignation. She fought it at first, but eventually stepped down under pressure. Deanne Fletcher, the other board member who had participated in the illegal vote, also resigned. New elections brought in more reasonable people. With the $102,000 plus attorney fees covered, I was able to replace all my tools and then some. I spent weeks shopping, both online and at specialty stores. I couldn't get back my grandfather's original hand planes, but I found similar vintage models that carried their own history. I bought top-of-the-line power tools, upgraded my equipment, and even had money left over to rebuild my emergency fund. The emotional damages were harder to quantify. $25,000 could not undo the 8 months of stress, anxiety, and unemployment. But it did help. I used some of it to continue therapy and took a short vacation to clear my head. I also made a donation to a local trade school in my grandfather's name, something I had always wanted to do. Most importantly, I was able to get back to work. My old employer did not have an opening, but with my tools replaced and good references, I landed a position with another construction firm. It felt incredible to hold a saw again, to measure and cut and build. I had not realized how much of my identity was tied up in my work until it was taken away. The legal victory also had ripples beyond my personal situation. A local news station picked up the story, running a segment about HOA overreach. The reporter interviewed me, Jennifer, and several other residents who had their own HOA horror stories. The publicity led to a state assembly member proposing new legislation to strengthen homeowner protections against HOA abuses. I also received calls from other people in similar situations, asking for advice or Jennifer's contact information. It turned out my experience was not unique. HOAs across California were seizing property, imposing unreasonable fines, and trampling on homeowner rights. My case became a reference point for others fighting back. About 6 months after the trial, I received a letter from the Riverside County District Attorney's Office. They had reviewed the sheriff's report I had filed and decided to pursue criminal charges against Brenda Morrison for grand theft. Apparently, the civil trial had provided enough evidence to support a criminal case. I was called to testify at a preliminary hearing. It was surreal to see Brenda in a criminal courtroom, facing potential jail time. The prosecutor, a sharp young woman named Amanda Reyes, walked me through the same basic facts I had testified to in civil court. Brenda's criminal defense attorney tried to argue that she had believed she was acting within her authority as HOA president, but the judge was not buying it. "Ignorance of the law is not a defense," Judge Catherine Liu said during the preliminary hearing. "The evidence suggests Ms. Morrison knowingly seized and disposed of property that did not belong to her, causing substantial financial harm. This case will proceed to trial." The criminal trial happened about 3 months later. I attended as much as I could, wanting to see it through. The prosecution presented much of the same evidence from the civil trial, plus additional testimony from the junk removal company and the second-hand tool shop. The jury in the criminal case deliberated for 2 days before returning a verdict: guilty of grand theft. Judge Liu sentenced Brenda to 18 months in county jail, though she suspended all but 90 days, meaning Brenda would serve 3 months and then be on probation for 3 years. She also ordered Brenda to pay restitution, though since I had already received the civil judgment, the restitution went to cover court costs. Seeing Brenda Morrison led away by a bailiff to begin her jail sentence felt like the final chapter closing. I did not take pleasure in her going to jail, but I did feel a sense of justice. She had abused her power, violated the law, and caused real harm. There had to be consequences for that. My life slowly returned to normal after everything was settled. I kept living in Meadowbrook Village, which surprised some people. But the new HOA board was reasonable, the neighborhood itself was nice, and I had built friendships with several neighbors who had supported me through the ordeal. The new board also revised the community guidelines, clarifying that residents could store personal work equipment without it being considered commercial use. They implemented new procedures for violation notices, requiring photographic proof and written records. They established an appeal process that gave homeowners a chance to contest violations before any action was taken. It was not perfect, but it was a lot better than what had existed under Brenda's reign. I also got more involved in the community. I attended HOA meetings regularly, volunteered for the architectural committee, and made sure my voice was heard on policy decisions. I had learned the hard way that disengaging from the HOA just gave people like Brenda Morrison free rein. The only way to prevent future abuses was to stay involved and hold the board accountable. One unexpected positive came from the whole experience. I met someone. During one of the HOA meetings about reforming the community guidelines, I started chatting with a woman named Whitney Sanders, who lived a few streets over. She was a graphic designer who worked from home and had her own frustrations with the previous board's nitpicky enforcement of aesthetic rules. We started getting coffee after meetings, then dinner, and eventually started dating. She understood what I had been through because she had witnessed the HOA drama firsthand. Having someone who got it, who did not think I was crazy for fighting so hard, meant everything. About a year after the trial, Whitney and I were having dinner at my place when she noticed the vintage hand planes displayed on a shelf in my workshop. "Are those the ones you told me about?" she asked. "The ones like your grandfather's." "Similar," I said. "Not the actual ones, but close enough. They remind me that even when things get taken away, you can rebuild." "That's a good philosophy," she said, smiling. We talked about the whole experience that night, something I did not do often because it still brought up difficult emotions. But with Whitney, it felt safe. "Do you regret buying here?" she asked. After everything that happened, I thought about it. Sometimes. But if I had let them drive me out, they would have won. And the community is better now because people stood up and demanded change. I'm proud of that. "You should be," she said. "You didn't just fight for yourself. You fought for all of us." That perspective helped. The lawsuit had never just been about me getting my tools back or receiving compensation. It had been about standing up to bullies, demanding accountability, and proving that homeowners have rights that even HOAs have to respect. Looking back now, almost 2 years after finding that changed lock on my storage unit, I can see how much I learned from the experience. I learned about the legal system, both its frustrations and its power to deliver justice. I learned about the importance of documentation and persistence. I learned that sometimes you have to fight even when the odds seem stacked against you. I also learned about community. The neighbors who supported me, who shared their own stories and attended the trial to show solidarity, reminded me that most people are decent and want fairness. The problem was not the community itself, but the small group of people who had seized power and abused it. My tools, carefully organized in my workshop and storage unit, are more than just equipment now. They are symbols of resilience and justice. Every time I pick up a saw or plane a piece of wood, I remember what I fought for and what I won. The $25,000 in emotional damages sits mostly untouched in a savings account. Part of me wants to use it for something meaningful, maybe start a fund to help other homeowners fight HOA abuse. Jennifer and I have talked about it a few times. She thinks there is a real need for that kind of support, especially for people who cannot afford legal representation. As for Brenda Morrison, I have not seen her since the criminal trial. I heard she moved out of Meadowbrook Village shortly after serving her jail time, relocating somewhere up north. I do not wish her ill, but I do not feel sorry for her either. She made choices, bad choices, and faced the consequences. The Meadowbrook Village HOA still exists, of course. HOAs are not going away, and in many ways they serve useful purposes. But the new board operates with transparency and respect for homeowners' rights. They enforce reasonable rules reasonably. They communicate clearly. They follow proper procedures. That is all I ever wanted. My career is back on track. I have been with my current employer for over a year now and recently got promoted to lead carpenter on a major commercial project. It feels good to be valued for my skills and experience. Whitney and I are talking about moving in together, maybe buying a house outside of an HOA community. We laugh about that, the idea that my experience has made me permanently skeptical of HOAs. But there is truth to it. I will never again sign an HOA agreement without reading every word and understanding exactly what powers I am giving to a board. On quiet evenings, I sometimes sit in my workshop and think about my grandfather. He taught me carpentry when I was young, patiently showing me how to measure twice and cut once, how to feel the grain of wood, how to take pride in craftsmanship. I wish I had his original tools, the ones Brenda Morrison threw away. But I carry his lessons with me, and that is more valuable than any hand plane. The whole experience taught me that justice is possible, but it requires fighting for it. Nobody was going to give me back my tools or hold the HOA accountable. I had to document everything, hire a lawyer, sit through depositions and trial and see it through to the end. It was exhausting and expensive and stressful, but it was worth it. Sometimes I get emails or messages from people who heard about my case and are dealing with their own HOA nightmares. I always respond with the same advice. Document everything, know your rights, do not be afraid to get a lawyer, and do not give up. The system can work if you are willing to push it. A few months ago, the state assembly member who proposed the HOA reform legislation invited me to Sacramento to testify in support of the bill. It was intimidating speaking to a room full of legislators, but I told my story and explained why stronger protections are needed. HOAs have a place in our communities, I said, but they cannot be allowed to act like petty dictators. Homeowners need real recourse when boards overstep their authority. What happened to me should not be possible under the law. The bill is still working its way through the legislature, but it has bipartisan support. Jennifer thinks it has a good chance of passing. If it does, it will require HOAs to provide written notice with photographic evidence before taking any action against a homeowner's property. Establish a mandatory mediation process for disputes, and create penalties for boards that violate homeowner rights. That would be a real legacy from my case, something that helps people I will never meet. I still live at 2847 Willow Creek Lane. My storage unit is full of tools again, properly organized and secured with a heavy-duty lock. Sometimes I walk past it and remember that morning I found it emptied out, the feeling of violation and helplessness. Then I remember the jury verdict, the look on Brenda Morrison's face when she realized she had lost, and the sense of justice finally served. Life has settled into a comfortable rhythm. I work hard during the week, spend time with Whitney on weekends, and stay engaged with the community. The lawsuit and everything that followed are part of my story now, but they do not define me. What defines me is what I build. Every house I frame, every cabinet I craft, every piece of furniture I make is a testament to skill, persistence, and integrity. Those are values my grandfather taught me, values that got me through the hardest period of my life, and values that will carry me forward. The check for $102,000 is long since deposited and spent on tools and recovery. But the real value of that verdict was not monetary. It was the affirmation that I was right to fight, that what happened to me was wrong, and that even powerful institutions can be held accountable when ordinary people refuse to back down. That is the lesson I carry with me. And that is the story I share when people ask about the HOA lawsuit. It is not just about tools or money or even justice, though those things matter. It is about standing up for yourself and others, about refusing to be bullied or silenced, and about trusting that the system, for all its flaws, can work when good people push it to. My workshop is my sanctuary now. The smell of sawdust, the feel of wood under my hands, the satisfaction of creating something solid and real, these things ground me and remind me who I am. The tools surrounding me, each one carefully chosen and valued, represent not just my profession but my victory over those who tried to take it all away. And every single day, when I pick up a tool and get to work, I think about how close I came to losing this. How Brenda Morrison's abuse of power almost destroyed my livelihood and my peace of mind. And I think about how fighting back, as hard and scary as it was, saved everything that matters. The Meadowbrook Village community is peaceful now. Kids play in the streets, neighbors chat over fences, and the HOA quietly does its job without drama or tyranny. It is what a community should be, and I am part of making it that way. Not just through the lawsuit, but through ongoing involvement, through speaking up at meetings, through being a good neighbor and a watchful citizen. That is the real work of democracy, whether at the national level or the neighborhood level. Participation, vigilance, accountability. As I close up my workshop tonight, I take one last look at my tools, my rebuilt collection that represents so much more than equipment. They represent resilience, justice, and the refusal to be a victim. They represent everything I fought for and everything I won. And tomorrow, I'll pick them up and get back to work, building things that last, just like my grandfather taught me. That is the best revenge, the best victory, and the best life. Creating, contributing, and carrying on, no matter what obstacles appear in your path. The HOA seized my storage unit full of tools, thinking they could make an example of me. Instead, a judge made them pay replacement cost plus emotional damages, and the whole community learned that abuse of power has consequences. That is a story worth telling, and I am proud it is mine.